most people watching at this time would not have had an opportunity to go through the commas and the full stops of the new law. From what you've gathered and from what's in the public domain, Mr. Lekhi, could you lay the context for this debate by telling us whether you think the changes in the laws taken together are a step in the right direction, and if so, to what extent? Let's start from there. Aman Lekhi.
Well, I find the Home Minister maligning the existing system, slandering it and running it down, which in my opinion is completely unwarranted. It's a very simplistic assertion based only on one aspect of the Penal Code, that is 1860, to say that it's the colonial legacy. It is not a colonial legacy because insofar as the method of criminal administration is concerned, there are certain standardized approaches. There's an adversarial method, an inquisitorial method. As for the Indian law is concerned, it's got elements of both. While combining elements of both methods, there are certain constitutional values which are present. The constitutional values affirm individual liberty. We have in our legal system presumption of innocence. We also have in our legal system a right to silence. We have an open adversarial system. We have open courts. And insofar as the administration is concerned, that is modern and the jurisprudence is current. So for the Home Minister to say that it's a revamp because we are undoing a colonial legacy shows a complete disconnect with reality, which is completely unwarranted. And it needlessly disparages the system and will create some kind of view about the existing legal system to create some unrest about it, which in my opinion is completely unwarranted too. I also feel that the method in which they brought it about is unthinking. I'll give an example where this is concerned. You have mentioned two things in this. I just happen to read whatever I read in the newspapers. One, mob lynching. Mob lynching is punishable with 7 years imprisonment. Mob lynching is murder. It's an aggravated form of murder. And mob lynching is concerned, you don't only look at the people indulging in mob lynching, you look at the people responsible for enforcement of the law. You deal with bystanders, deal with others. It's an aggravated form of murder. For an aggravated form of murder, you have a less punishment. You talk about sedition. I'm very much in favor of sedition, but that's not an issue right now. Sedition has the expression subversive activities. Subversive activities along with secession and other activities. Now, subversion is an element of secession. If you have subversion apart from secession, what will subversion contain? So it's an expansive definition which enlarges the scope of interference which is there in involvement. As far as aspects are concerned, the method in which this has been brought about, I have a very strong reservation that is concerned. If this is well thought out, it should have been in the list of legislation which the government should have brought. It shouldn't have been part of the supplementary legislation. So what does that show? I feel that is an attention diverting device because you bring a bill, the bill is not law, the bill goes to standing committee, the standing committee's recommendation is not binding on the parliament, the matter goes into limbo, we are discussing something which is not the law today, which may never be the law, and the law which stands today is discredited. This is no way how a government should work.
Wow, those are strong, scathing opening comments from Aman Lekhi. Let me go across to Sanjay Hegde. You're saying it will never be the law. I wonder why you say that. I'll come back to you in a moment. Let me just get some opening comments from everybody else as well. Sanjay Hegde, you just heard Aman Lekhi taking apart the very premise behind which this law has been introduced, saying there was no need. The fact that the Indian legal system as it stands is cumbersome, and while Aman Lekhi put up a strong defense for the way things are, many watching at this time would agree that if things are simpler, faster, speedier, more effective, justice would be better served. What's your view on the manner in which the change is being brought and the need for the change and the extent to which, once and if these changes are implemented, the legal system, will it be better than the past?
Well, firstly, I do agree with Aman that this has been brought suddenly. And for that, the best proof is the draft itself. It's an incomplete draft full of legislative howlers. Your basic question on sedition. Sedition has been replaced with Section 150, acts endangering sovereignty, unity and integrity of India. Now, if I were to read it out, for instance, or by electronic communication, or by use of financial mean, when you actually mean means by financial means, then you have an explanation which is entirely which is incomplete. Comments expressing disapprobation of the measures or administrative or other action with a view to obtain their alteration by lawful means without exciting or attempting to excite the activities referred to in this section. Full stop. do not come within the mischief of this section, or you say that this is not covered. Incomplete sentences, half written, wrong words, and they are galore. There is a plagiarism device called Turnitin, which lots of law schools use. Somebody ran put this on Turnitin, and 83% of it is copied from the existing Indian Penal Code. What has happened is a shuffling of sections. The 17% which could have, if you've changed, you might as well have brought in an amendment act to the Indian Penal Code. I don't know what the reason was. You wanted to have something called Bharatiya, something this. Fine. Have a vision. Whatever work you submit to Parliament, please have the decency to submit a complete draft before it goes to the Parliamentary Committee. It looks like a half-complete draft was suddenly pulled out of the Legislative Department and shoved down Parliament's throat. Now let me tell you why Aman says that it may never become the law. It now goes to a Parliamentary Committee, and the Parliamentary Committee obviously will have to put all this together. Now there are maybe 2 or 3 sessions of Parliament, of this Parliament. This is an act, these acts have been brought in the Lok Sabha. By the time it comes up for passing in this Lok Sabha, we do not know whether it will happen or not. Otherwise, this will lapse. If it becomes the law, then also people have warned about not only such an overbroad section of subversive activities, all this that I've told you so far could very well qualify as subversive activity. So, we are going to have a generation of lawyers and judges breaking their heads over something that could have been avoided with a little bit of care at the legislative stage.
Okay, let me get Nalini's perspective on the reasons that the government has stated for bringing this law. Now, I understand both from Aman and Sanjay's perspective, everything that they've learned, all the sections that they know and have referred to as second nature now need to be unlearned and relearned. That's irritating and complicated. But from the government's perspective, what is it that they're hoping to achieve, Nalini?
Well, Rahul, whatever is it that the government is hoping to achieve, I don't understand why it could not be done by way of an amendment. So that the things that were there in the existing IPC, CRPC, like Mr. Sanjay Hegde says, that almost 85% of it has been picked up from the existing laws. So the changes that the government wanted to bring about could have been done by way of an amendment, which would have made things easier, not just for the lawyers who, like you correctly said, will have to unlearn and relearn, but also for the judges. Every time that a lawyer now references to a particular section, the judge might not know what he is talking about. He'll have to go back to the bare act. He'll have to see what section it is. So instead of the objective of the government, which is to expedite the proceeding, it might prolong the proceeding even more, because there'll be a significant time that both the bench as well as the bar is going to take to get accommodated to this.
Okay.